Welcome to End of the Line for Non-Competes, what employers must know about the FTC's new rule. Look, this is a seismic shift in employment law, and it can really redefine how you structure your team and protect your business interests. The landscapes for non-competes are really going to change dramatically, and you need to make sure that you're ready. This presentation will explain in clear and simple terms the FTC's non-compete clause rule, and it will provide strategic insights to help you adapt effectively. So stay with us to ensure your business remains compliant and competitive in this new legal environment. First, a simple overview of the non-compete clause rule. And if you take anything from this presentation, take this slide, which really distills it in these two simple bullet points, one bullet point with subparts. So after September 4th, 2024, it's an unfair method of competition for persons to, among other things, enter into non-compete clauses with any worker. And that's a senior executive or otherwise. So any other worker, and that's really important. So for anyone, any worker after September 4th, 2024, no non-compete clauses. And we'll explain later what a non-compete clause actually is. But for pre-existing non-competes after September 4th, 2024, this means you already had them before September 4th, 2024. So afterwards, what's going to happen? Okay, this is what's going to happen afterwards. We're going to look at those two categories. The senior executives, for those people, these non-compete clauses, they are enforceable after September 4th, 2024. For other workers, they are not enforceable after September 4th, 2024. And the employer has to provide notice to these people that the non-compete clause is no longer enforceable. So what's a non-compete clause? So this is defined in the rule by the FTC as a term or condition of employment that prohibits, and I added the emphasis in these words, prohibits a worker from, penalizes a worker for, or functions to prevent a worker from. There's a lot of discussion in the comments to the rule and the analysis on this functions to prevent, why it was added to really broaden the rule. So if it looks like a duck, quacks like a duck, it's a duck. So you can have other things like an NDA or confidentiality agreement, which are permissible unless they function to prevent a worker from, in the same way that a non-compete would. And now I'm going to go to the rest. Seeking or accepting work in, and I'm emphasizing this, to United States. So this is a limitation on the rule. It only applies to work in the United States and operating a business in the United States with a different person, where such work would begin after the conclusion of the employment that includes the term or condition, meaning the non-compete clause. I also emphasize after the conclusion of the employment. It's important to remember when we're understanding this rule is it's not doing anything when the employee is still employed. So there can still be restrictions on concurrent employment, on moonlighting, on doing other things to not compete with the company while that worker is still employed by the company. What this rule is intended to encompass is work post-employment or after the conclusion of employment. Second part here, operating a business in the United States after the conclusion of the employment. That includes the term or condition. Okay, so seeking or attempting to work and operating a business, prohibiting, penalizing, functioning to prevent. That's a non-compete. I know it's a mouthful, but hopefully I've distilled that for you. So what's a worker? A worker is also broadly classified by the FTC, and it's classified as not only an employee, but individuals classified as independent contractors and other kinds of workers. This is pretty important. This individuals classified as independent contractors. The FTC didn't want there to be any question about whether someone's really an employee or really an independent contractor. So they said individuals classified as independent contractors, because essentially, according to the FTC in the analysis, a lot of people are improperly classified as independent contractors. So they wanted to make clear that essentially everyone's covered as a worker under this rule. So we mentioned that pre-existing non-competes for senior executives are accepted from the application of this rule. So what's a senior executive? Well, senior executive is someone that earns more than $151,164 a year, and they're in a policy-making position. What's a policy-making position? That's the president, CEO, or other office with policy-making authority. What's policy-making authority? That is, the person has the final authority, they don't just sit in the meeting, they have the final authority to make the decision, to make policy decisions that control significant aspects of the whole business, not just a subsidiary of the business or a division of the business or a department of the business, but the whole business. And the FTC really wrangled with this. They wanted to encompass the highest level of people in the company, because they didn't want to exclude these other people who they feel like non-competes are used most unfairly against. Okay, but what about the pre-existing non-competes for the other workers? So for the other workers, they are not going to be enforceable after September 4th, 2024. The FTC provided a model notice about non-enforcement of non-competes. They provided a lot of options for providing notice, including text message. And they noted in the comments, and I agree with this, that a mass email to current and former other workers, not the senior executives, we want to carve those out. We don't want to confuse them and say they're not subject to non-competes, but these other workers, we need to send a mass email before September 4, 2024, letting them know about the non-enforcement of non-competes. So I say before September 4, 2024. As I'll note later in the presentation, there's already legal challenges. There's going to be more legal challenges. I would wait as close to the date as possible, because you don't know what's going to happen with this rule. But as far as preparing for other aspects of the rule, I would get my list of current former employees together, the contact information, so you can get ready to go and send this mass email out notifying these other workers that they're no longer subject to the non-compete, so you can be in compliance of the rule. So here's a copy of the model notice. Essentially, if you follow this general outline, then you're ensured compliance with it. It's a good idea to follow this notice. Does it have to be word for word? No. So what if you don't do these things? Well, the FTC can't obtain civil penalties or other monetary relief for using an unfair method of competition, but this is important. It can obtain civil penalties if it sends you a cease and desist first, and then you fail to cease and desist. And look, fighting with the FTC is nasty. It's super expensive. As soon as you get a cease and desist, you should immediately contact your attorney, but definitely steps should be taken beforehand to comply with the rules. It's really seriously on one of my bucket lists. Don't get embroiled with the FTC or any other government organization that can really give you a lot of grief. There's lots of exceptions to the FTC's non-compete clause rule. So first of all, it says that if the cause of action accrued prior to September 4th, 2024, that cause of action is not going to be extinguished. You're still going to have it. So that doesn't mean you have to sue before September 4th, 2024. It just means your cause of action had to accrue. Essentially, someone breached an existing non-compete agreement. This is really important. Non-competes linked to the sales of businesses. They're used all the time to tie down goodwill, and you can still do that when buying or selling a business. The franchisee in a franchisee-franchisor relationship is excluded because the FTC views that as more of a business relationship rather than employer-employee. But look, they want to make sure that not the individual who worked for the franchisee or franchisor. So that person, this non-compete rule is going to apply to, but not in franchisee-franchisor agreements. Another exception is you can enforce or make representations about the non-compete where you have a good faith basis to believe the non-compete clause is inapplicable. Look, and what I think that is essentially if you are protecting your business in other ways, but the FTC later deems that to have gone too far and to actually fall within the purview of being a non-compete clause. If you had a good faith basis to believe that what you were doing was okay, then you can be accepted from this. Banks don't fall under the jurisdiction. I mentioned this earlier, work and operating a business in the U.S. Some nonprofits, be careful here. So look, nonprofits don't fall within the FTC generally. However, significant analysis was given in the rule, which gives a test I'm not going to go into. But just because there's tax exempt status doesn't mean you're accepted from the rule. There's more to that analysis that the FTC would look through. So how do we continue to protect your business following this rule? First of all, tie up the non-competes with senior executives before September 4th, 2024. Again, senior executives is really high up in the company. I'm not saying go ahead and just get everyone to sign non-competes because that's not going to work. You need to just focus on who truly is a senior executive. I would think if they really were a senior executive, there would already be a non-compete in place, which is why FTC probably wasn't too worried about people running out to tie up loose ends at this point. Because they're like, look, if they're really a senior executive, they probably already have a non-compete. But look, if you don't, if there's someone that qualifies as a senior executive, get this non-compete in place right now. I also mentioned restraints on concurrent employment are allowed. You can still do that, still breach a fiduciary duty for someone to compete with you while they're employed. It could be breach of contracts. You can have a non-compete clause that prevents them from competing with you and hurting you while they're employed with you, or moonlighting, or working two jobs, or doing anything in a conflicting position. Things like that you could include in your employment agreements. NDAs or confidentiality agreements. FTC several times mentions that garden variety NDAs are fine. You can use them to protect your confidential information, your customer list, things like that. Traps are still allowed. Traps, what is it? Essentially, if you provide training to someone, then you can ask if they leave within a certain period of time to repay the value of the training provided. Forfeiture for compensation clauses is, for example, if you leave the company, you might have to forfeit a bonus or some other right given to you by the company. Those are still generally allowed. Garden leave agreements, which is you continue to stay employed. They're like, to make sure you don't compete with us, we're just going to keep paying you, but we don't need your services. We're going to keep paying you. Technically, that's concurrent employment. Remember, restrictions on concurrent employment are allowed. So that doesn't even fall within this post-employment thing. Now, I mentioned these things and I said generally they're allowed. This is the really, really, really important part, and why you have to have an attorney work with you and really tailoring these provisions to your business. These provisions cannot be so broad or onerous that they have the same functional effect as a term or condition prohibiting or penalizing a worker from seeking or accepting other work or starting a business after their employment ends. In other words, they can't function or operate as a non-compete clause. If they do, then they're non-compete clause, and you can't do that under the rule. So you can protect your business, but you can't do it through the use of non-compete clauses. There's a few other things that you can do to protect your business. An invention and assignment agreement, also patent. Those are two intellectual property things, just to make sure that the things that your employees are developing for your business, that you have the rights to them. Also, I'm throwing in two federal statutes. One is the Uniform Trade Secrets Act, and one is the Defend Trade Secrets Act, which is a vehicle for providing protection for confidential information. And I suspect if we're looking at things like customer lists and stuff like that, at least in Texas, that going through a confidentiality agreement or the argument that it was confidential information was kind of like one of your last arguments that you made. You would lead with the non-compete argument and you would end with the confidentiality agreement argument. Well, now that the non-compete argument is going to be largely gone in the future, confidentiality and these other things and protecting the customer list and other confidential and proprietary information and trade secrets is going to be ever more important. And I think you're going to see that that's going to lead the argument when an employer is going out and trying to protect their goodwill, their reputation, their information post an employee leaving the company. So mentioned really briefly earlier that there's already some legal challenges to the rule. There's going to be more legal challenges to the rule. There could also be an administrative change, FTC's administrative agency. So there can be changes that could happen that could affect this rule. There could be legislation that affects this rule. Your guess is as good as mine. I do know there's going to be years of fights following this because this is such a big deal. Like, this is a really big deal in the world of employment law. So there's going to be a lot of fights. So if you want to connect, you can email firm@johnsonlaw.com. And if you email that address, someone at the firm will respond with the model notice if you were so request, or with a PDF copy of the rule and all the comments and analysis. I believe it was like 150 pages long with 3 columns of text. If you want to nerd out like that and really read it. Otherwise, this video is good enough for you. You can also schedule a consult at calendly.com/Chris Johnson, and that's JOHNSEN. You can also use the scheduling widget on the website, www.johnsonlaw.com, or you can just simply scan this QR code. It will take you to the Calendly link where you can schedule that consultation if you want to discuss non-compete agreements or the other restrictive covenants and what we're doing for our clients here at Johnson Law to prepare for this sea change. Thanks.